The Yugoslavia Tribunal was an international court designed to put war criminals on trial for the crimes they committed in the region of the world that used to be called Yugoslavia. That's because when Yugoslavia broke apart in 1991, it turned into a bloody civil war until 2001. The different sides were fighting over who would control which parts of the former Yugoslavia's territory, and each side had their own ethnic group. Serbia had the Serb ethnic group, Montenegro had the Montenegrins, Croatia had Croats, etc. And you could live in Croatia, have a Croatian passport, but not be an ethnic Croat. The same way I could move to India, get an Indian passport, but I would still be part of the Dutch ethnic group. And the different sides tried conquering territory where the majority of people were of their own ethnic group. So Serbia, for example, invaded a lot of regions with Serbian majorities. As a result, the Yugoslav War became an ethnic war. When a region was conquered, anyone who had a different religion, ethnicity or culture could be persecuted. Some were deported, some were executed, and some were sent to detention camps. But don't worry, we won't show you any pictures or videos of this. So if you value your own sanity, you can still watch this video without problems. I sacrificed some of my own peace of mind, so you people don't have to. Chapter 1. Creating a Tribunal. As people fled the war zone, they started talking about what had been done to them, how their houses were burned, how the military targeted civilians, and how entire communities were destroyed. This reminded a lot of Europeans of what happened during World War II. And after World War II, the leaders of Japan and Germany were put on trial for their actions during that war. And so the German foreign minister proposed an international tribunal for the war crimes committed in Yugoslavia. But there was a problem. The Germans and Japanese were put on trial by their victims and the winners of the war. A lot of people saw this as victor's justice, meaning that they were only put on trial because they lost the war. In order to avoid the same controversy, it decided that the United Nations would create a tribunal. And they started in October of 1992 by sending investigators to the former Yugoslavia, and there they could confirm the stories refugees were telling them. Such as a man called Milan Bebic, leader of the Serbian occupation forces in Croatia between 1991 and 1992. While he did not order the atrocities, as a regional leader he did everything he could to help them along. He was sentenced to 13 years in prison in 2004 and passed away in 2006. When the UN had enough evidence, they decided to set up the tribunal itself. On May 25, 1993, the UN Security Council formally established the International Criminal Tribunal for the former Yugoslavia, or simply called Yugoslavia Tribunal. And this tribunal was allowed to prosecute all war crimes in the former Yugoslavia from 1991 onward, about 4 months after the war started. If someone committed a crime before 1991 or in a different area of the world, they could not be prosecuted at this tribunal. In order to decide what crimes a person could be put on trial for, they looked at international laws. For example, there are the Geneva Conventions and the Genocide Convention, which states that in times of war, prisoners have to be treated well, you can't target civilians, and you can't abuse people. Yugoslavia signed these treaties. Therefore, it was illegal to commit war crimes according to their own laws. Based on these treaties, a person could be put on trial for 4 reasons. The first is grave breaches of the Geneva Conventions. This includes killing prisoners, abuse, or excessive destruction of civilian property, among other things. Secondly, violations of the laws or customs of war. This includes targeting religious buildings, historical artifacts, or stealing works of art. The third is crimes against humanity. This includes extermination and deportation, enslavement and imprisonment of civilians, and persecuting or targeting people based on their political, religious, or ethnic background. And lastly 4, genocide. This means targeting a certain ethnic, religious, or national group within the population with the goal of destroying that group of people. But the defense argued that the entire tribunal was illegal. Duško Tadić was the first person to go on trial at the Yugoslavia Tribunal in 1995. He was a political leader who helped to create a system of deportations and detention camps in Bosnia. And he argued that while he did do it, he wasn't guilty of war crimes. He argued that the tribunal didn't have the right to put him on trial. He had two main arguments. The first was that the treaties only cover international wars, not civil wars. The Yugoslav War was a civil war, and therefore technically not a war crime, but the court wasn't convinced by this argument. His second argument was that the UN is a political organization and politicians can't decide to put people on trial. Only judicial organizations can do that, like a court. But there was no international criminal court and therefore he could not be put on trial. But the tribunal concluded that every court system was created by politicians after a crime had been committed. And so the very first court in any territory is created by politicians. The Yugoslav Tribunal was simply the first international court system created by the United Nations. And therefore, it should be allowed to handle these war crimes because someone has to be the first. This would later become the basis for the International Criminal Court that was founded in 2014. Duško Tadić was found guilty of grave breaches of the Geneva Convention. He was sentenced to 20 years in prison in Germany, but was granted early release after just 13 years on July 17, 2008. The tribunal could put people on trial if they themselves committed a crime or if they were responsible for one. So, for example, if you are a general, you find out your troops committed an atrocity, and you did nothing to punish them or prevent more in the future, then you are held responsible. This concept is called command responsibility. You are responsible for the troops under your command. However, if you were not aware of the crimes, refused to participate in them, had no power to stop them, or did everything in your power to prevent them, then you couldn't be held accountable. And it became the goal of the investigators to find out exactly who was responsible for what crime so that they could find the people in charge and put them on trial. One such person was Radovan Karadzic, president of Bosnia, a region within Bosnia-Herzegovina, and supreme commander of the Bosnian army. That army committed various war crimes from the Srebrenica massacre to persecution, deportation, and attacks on civilians, meaning that he had the power to stop this but chose not to. He was eventually found guilty of genocide, crimes against humanity, and violating the laws of war, and he was sentenced to 40 years in prison. He was 71 when the sentence was passed. He will either die in prison or set a record for the oldest inmate in human history upon his release. Chapter 2. The Evidence. The way the tribunal gathered evidence was to first listen to the stories of refugees. The investigators would travel all over the world to find them, and while one witness isn't good enough evidence, having multiple people tell the same thing means it likely did happen. Then the investigators would locate the potential crime scene by looking at satellite images or nearby fresh graves, using government documents, and sometimes even intercepting radio messages. The team would then travel with armed guards to the site. This was often difficult as bridges were destroyed and soldiers might still be fighting in the area because they were investigating while the war was still going on. Once they arrived, they would look for any evidence they could find. Bodies could have identification papers on them or have personal items that belonged to a particular ethnic group. This told the investigators where these people came from. Autopsy would reveal the cause of death, as well as any physical traumas they underwent before death. If a person was killed with a bullet, they could analyze exactly which bullets were used and who was using them. Bullets are kept in casings. When you fire a bullet, the casing drops on the ground. And every type of bullet has its own type of casing. They would look at the casings to find out where these people were killed. They could then look at which units were operating in the area and which units were using those types of bullets. They would then look at satellite images, troop movements, or even footage from TV crews to determine who committed the crime. They could then use military records to see who was in command of that unit. Using all this information, the investigators were able to identify who was killed, where they were killed, who killed them, and who was in charge of all this killing. After all, a massacre requires multiple people, and when multiple people are involved, someone is usually in charge, especially in a war zone. If they found multiple units committing war crimes, they would look if they had the same general. If it turned out that the soldiers of a particular general had multiple cases of atrocities, then it was likely this general knew about at least some of them. They could then check if this general did anything to stop these war crimes. If the general did nothing about it, then he was likely guilty of a crime. and they would create a pattern of who was responsible for which crimes to find out some sort of method to all this madness. The investigators would then go to the Yugoslavia Tribunal, present their findings, and the judges would then decide whether this person should be indicted or not. However, if the investigators arrived at a crime scene but couldn't find any conclusive evidence, then it's likely that the people in charge also couldn't have found any evidence either. After all, if some of the best investigators in the world can't find any evidence, then the leaders probably also couldn't find any evidence. And therefore, they could not be held responsible for a crime if they could not have known about it. Sometimes it wasn't difficult to find evidence though, such as the case of Srebrenica, where over 7,000 Bosnian men and boys were killed right in front of the eyes of Dutch soldiers. It was relatively easy to find the crime scene, locate the bodies, and find out who was in charge. Other times it was a lot more difficult. For example, there were 3 detention camps in the Bosnian municipality of Prijedor. When the investigators wanted to go to these camps, they were stopped by the local police chief. This police chief was responsible for organizing the deportations in that region. He was afraid he might be put on trial if his involvement was discovered. So he did not allow investigators access to the area. The investigators had to come back with 200 NATO troops to convince the local police chief to allow access. They went to the Omarska camp. I won't tell you exactly what happened here. If you really want to know, I've left sources in the description for you to read. You can also go to the official website of the Yugoslavia Tribunal, where they have detailed explanations of what exactly went on. But if you value your own sanity, I strongly recommend you do not look at the sources. However, I will give you a quote from one of the investigators. When they went to the camp and turned on the blacklights to look for bloodstains, the walls lit up like a Christmas tree. In another camp, they found an interrogation room that was so full of blood they could identify shoe prints using their blacklights. One print was so well preserved that they were able to tell the exact brand of shoe this person was using. They could use this evidence to see who at this camp wore those shoes in that size. Using all this evidence, they were able to indict 4 more people of the detention camp. Zdravko Music, camp commander. He was found guilty of breaching the Geneva Conventions and sentenced to only 9 years in prison because he did not personally participate in the crimes. He was released after serving 2/3 of his sentence on July 18, 2003, and he died in 2020 when he drowned after having a stroke. Hasim Delic, his deputy commander and later commander himself. He was found guilty of grave breaches against the Geneva Convention and sentenced to 18 years in prison. He was granted early release on June 24, 2008. Esad Lancho, a camp guard. He willingly participated in the atrocities, but was not in charge. He was sentenced to 15 years in prison and granted early release on April 13, 2006. Zecnir Delalic, commander of the Bosnian army who coordinated Bosnian forces in the area. The tribunal concluded that while he was aware of the crimes, there was no evidence that he committed any himself, and he did not have enough power to stop the atrocities either. Therefore, he was found not guilty on all charges and released immediately on February 20th, 2001. They also found evidence that local police chief had been to these camps. His name was Simo Driljaka. He would give tours in these camps for various political leaders. He was indicted for genocide. However, when they tried to arrest him, he was killed in the shootout in 1997. When the war ended in most of Yugoslavia, the investigators gained access to a wide range of government documents from nearly all sides. This helped them to identify more potential crime scenes and discover even more potential war criminals. Some of these documents might be incriminating for the leaders of these countries, and in a lot of cases it was very difficult to gain access to these incriminating documents. But over time, these leaders were removed from power, and in order to establish good relations with European countries, they handed over these documents to the tribunal. By 2000, all the countries were handing over documents. Chapter 3. Arrests. Now that they had all the evidence, they could start arresting people. Between 1995 and 2004, 161 people were charged with war crimes, from soldiers on the ground all the way to the generals, presidents, and prime ministers. For example, Ratko Mladic, nicknamed the Butcher of Bosnia, was a high-ranking general in the Bosnian army. Troops under his command committed the Srebrenica massacre and the bloody siege of Sarajevo. He was found guilty of genocide, crimes against humanity, and breaching the rules of war. He was sentenced to life imprisonment and is serving out his sentence in the Netherlands. But there was a problem. The tribunal didn't have a police force to arrest anyone. So countries had to arrest the potential war criminals themselves. But most former Yugoslavia countries didn't want to do this because these people helped fight in the war. Some of them were even considered war heroes. So how were they going to be convinced to hand them over? Well, these countries wanted to join NATO and the EU for military and economic purposes. And they would only gain membership if they handed over all of the indicted people who had that country's nationality. In fact, Croatia and EU were supposed to start talking about joining the Union in March 2005, but the EU postponed these talks because the last indicted Croat had not yet been captured. His name was Ante Gotovina, a general in the Croatian army. He was charged with helping to organize the murder and deportation of Serb civilians. He was indicted in 2001 and went into hiding. Croatia couldn't locate him. The USA gave a $5 million bounty, and members of the tribunal even went to the Vatican, asking them if he was hiding in one of their churches. But in the end, he was caught by the Spanish police on the Canary Islands on December 7, 2015. He was eventually sentenced to 24 years in prison. However, on appeal, the tribunal concluded that there wasn't enough evidence, and he was acquitted of all charges. He spent 7 years in jail awaiting trial and was released on November 16, 2012. The defendants would be detained in The Hague, about 3 kilometers from the courthouse. Each defendant had their own private cell with a toilet, shower, radio, TV, and computer. They had a shared library, gym, and kitchen they could use. They tried making the cells look like a university residence instead of a jail. Hey, fun fact. I once lived in university housing that was designed by a prison architect, and it didn't look half as nice as this actual prison. And the reason this prison looks so nice is because the court wanted to emphasize that they were innocent before proven guilty. Chapter 4. The Trial. In order to determine how the trials should work, they looked at previous international trials such as the Nuremberg and Tokyo trials, which were tribunals used to put the leaders of Germany and Japan on trial for war crimes. And a big criticism of them was that a lot of the countries who put them on trial had committed those same crimes themselves. And many of the judges were from countries that had been occupied. And how could you possibly be objective after such an experience? So it was decided that all members of the UN would get to elect the judges. They would elect a total of 14 judges every 4 years, each coming from a different nationality. And the judges came from all over the world, from China to Zambia to Jamaica. After a person received a sentence, they would not be allowed to go to prison in a former Yugoslavia country. During the Tokyo trial, for example, a man called Okinori Kaya was sentenced to 20 years in prison for war crimes. He was released after 7 years by his friends in the government, and after being convicted as a war criminal, he returned to politics and became Minister of Justice. So, to avoid this from happening again, the criminals were imprisoned in foreign countries such as the UK or Finland. And the person who was sent to prison could have their sentence reduced for 2 reasons. The first is that they already spent time in jail while awaiting trial. So if a person was already in jail for 3 years before they were found guilty, they could have their sentence reduced by 3 years. Additionally, if they showed genuine remorse for their actions, they could be released after serving just 2/3 of their sentence. So if a person was sentenced to 12 years in prison, then their sentence could be reduced by 4 years to a total of 8 years in prison. But because they were already in jail for 3 years, they would only have to be in prison for another 5 years after receiving their sentence. This is why so many war criminals were released early. The prosecution often called over a dozen witnesses for each person on trial, and these witnesses were usually scared to testify. They were afraid of retribution from their supporters. They felt ashamed they were abused, or scared to come face to face with their abuser. and so the tribunal called together experts from all over the world to figure out how to protect these witnesses. They created a framework where the witnesses' names were withheld from the public. Their testimony was only released publicly in writing, and they sat behind a screen when in court in order to hide their appearance. Upon returning to their home, the local police would provide them with protection, and if everything else failed, they would be relocated to another country and live anonymously there. These measures are standard today in a lot of countries, and these countries usually base their own witness protection on that of the Yugoslavia Tribunal. There were some cases where witness protection wasn't good enough, such as the case of Ramush Haradinaj, a commander in the Kosovo army during the Kosovo War. He was Prime Minister of Kosovo when he was indicted, and there were suspicions that multiple witnesses were intimidated. For example, a key witness died in a car crash in Montenegro, though the police say they found no evidence that it was on purpose. 2 more key witnesses decided not to appear in court after this event, so we don't actually know for certain. However, he was acquitted due to a lack of evidence. He rejoined politics and became Prime Minister between 2017 and 2020. But in general, the prosecution's job was mostly about gathering enough evidence for their cases, because in general the crimes were easy to prove, but it was much more difficult to prove that a particular defendant committed a particular crime, or that a particular defendant allowed a particular crime to occur. Most of the people who were acquitted were because the prosecution couldn't prove that a person was responsible. And the most difficult case of them all was that of the Serbian president, Slobodan Milosevic. He was indicted multiple times as new atrocities came to light, deporting 800,000 Kosovans from their homes, detention camps, and for doing nothing while his army genocided their way across the former Yugoslavia. But most of the evidence was in Serbia, and of course the Serbian president didn't allow investigators into Serbia because they might find evidence against him. But then Serbia and Kosovo went to war in 1999, and those 800,000 Kosovans began telling stories of their atrocities. A year later, in 2000, President Milosevic was ousted and he became Citizen Milosevic, and the new government allowed the investigators access to the potential crime scenes. In Kosovo, they discovered mass graves that were empty. They eventually found the bodies in other mass graves in Serbia. This meant that someone had moved the bodies. And this could only mean one thing. Someone gave the order to move the bodies. But if someone gave the order, they must have known there was a mass grave there. And if they knew there was a mass grave there, they knew someone had committed a massacre and dumped the bodies there. And the prosecution concluded that a high-ranking official was aware of the crimes and tried to cover it up by moving the bodies. After all, if the government thought these people died under natural circumstances, then why would they move the bodies? And you can't cover up a crime if you don't even know about the crime. The prosecution looked at government documents, radio messages, and witness testimonies, and they were able to conclude that the person who gave this order was no other than President Slobodan Milosevic himself. He was arrested on April 1st, 2001. He pleaded not guilty and chose to represent himself in court. He argued that all the atrocities committed under his rule were the fault of NATO. He argued that NATO joined the war against Serbia by bombing Serbian targets. This left Serbia at a severe disadvantage in the war, and that therefore Serbia was forced to use atrocities in order to offset this disadvantage, and that therefore none of this would have happened if NATO had never interfered. The prosecution simply pulled out hundreds of documents, witness testimonies, and crimes that happened before NATO started bombing Serbian forces and before a UN peacekeeping mission was established. His trial ended on March 11, 2006, when he died of a heart attack. The tribunal later concluded that while he was not guilty of ordering his troops to commit war crimes, he was fully aware of them and did nothing to stop them. Chapter 5. The Defense. The defense lawyers had few compelling arguments for their clients. The people on trial usually had so much evidence against them that there was little point in denying the allegations, but about 20% were acquitted of all charges. The strategy the lawyers used was to point out that while there was evidence to convict the defendant, there simply wasn't enough evidence to be certain that this was the person who committed the crime. Their strategy largely revolved around trying to discredit the defense's witnesses, making sure the defendants weren't accused of more than they actually did, and arguing that there simply wasn't enough evidence to convict their client. As an example, let's look at 3 cases. The first is that of Dragoljub Kunarak, a commander of a reconnaissance unit in the Bosnian army. He ordered his men to force themselves upon civilian populations of other ethnic groups, but they usually did so without any other witnesses. The defense argued that if there are no other witnesses, then there wasn't enough evidence to convict them. But the prosecution argued back that a person cannot consent to being intimate with their captors, and it was highly unlikely that these people would just make up these stories, and therefore argued that such cases don't require other witnesses. The tribunal agreed and found him guilty of crimes against humanity and violation of the rules of war. He was sentenced to 28 years in prison in 2001 and is currently serving his sentence in Germany. Radomir Kovac, Kunarak's sub-commander. He was also found guilty of crimes against humanity and violations of the rules of war. He was sentenced to only 20 years in prison because of his lower rank, and was granted early release on June 30th, 2013 after serving 2/3 of his sentence. Zoran Vukovic, another sub-commander, also charged with abusing civilians and also found guilty of crimes against humanity and violating the rules of war. He was sentenced to 12 years in prison, but released only 6 years later on March 11th, 2008. Overall, the defense complained that they didn't have enough time and resources to do their job properly. To give an example, because this was the 90s, it wasn't yet possible to look everything up on the internet. So the tribunal had a library with legal documents, so that if a lawyer had to look up a specific law, a specific court case, or a specific regulation, they could go there to do so. But the defense wasn't allowed access to the library. Officially, the reason was to make sure that the defense wouldn't gain access to secret documents from the prosecution. Instead of buying 2 of every documents for 2 libraries, the defense had to go to the local library to get legal documents. In fact, the defense wasn't even allowed to eat in the cafeteria. They were given special identification cards which banned them from certain areas of the building, and they needed to ask permission every time they wanted to enter their own office. This made the defense feel uncomfortable, and uncomfortable people can't do their job as well as comfortable people can. And most defense lawyers complained they didn't have enough time to prepare for trial, and in fact, most cases at the tribunal were appealed, because if you appeal, you have to do the trial all over again. In this case, the defense lawyers the time they needed to prepare a proper defense. And this is likely the reason why so many sentences were reduced after appeal. The defense could finally make a good defense. And this is a personal note, but if you've ever wondered why lawyers will take on war criminals as their clients, it's not because they agree with them. They generally do it because they believe that a person should only be convicted of the crimes they are actually guilty of. The defense lawyers eventually formed a union to force the tribunal to give them what they needed. For example, the defense was given computers. This allowed them to search words in documents instead of having to read every single document yourself. But the prosecution kept sending all the files in paper format, because the tribunal was afraid that digital documents were too easy to smuggle out of the tribunal for the defense. And the defense lawyers had to negotiate with the tribunal to please be allowed to have a single flash drive which could be tracked and used only to transfer the tribunal documents to their computer. The defense lawyers didn't have the right resources, didn't have enough time, and they didn't have enough training. Most defense lawyers were from the former Yugoslavia, where the legal system worked differently. For example, lawyers didn't do cross-examination, meaning Yugoslav lawyers had no experience with questioning witnesses in court. The tribunal created a manual for the lawyers, but only for the prosecution. So the defense had to make their own manual. So on top of being defense lawyers, they also had to negotiate with the tribunal for access to vital documents, create a manual for themselves and future lawyers at the tribunal, and give training courses. While the prosecution had all these things handed to them from the start. And so, finally, after years and years of struggling, the defense finally came together around the year 2000. Chapter 6. The Sentences. Now that they had the evidence, it was time to put people on trial. Between 1995 and 2004, 161 people were sent an indictment. from soldiers underground to presidents behind their desks. There were 95 Serbs, 29 Croats, 9 Albanians, 9 Bosniaks, 2 Macedonians, and 2 Montenegrins, with several others whose nationality is unknown because their indictment was withdrawn. And if a person wasn't put on trial, there was no need to publish their personal information to the world. Unfortunately, we can't cover all 161 defendants, so instead we will go over some of the notable defendants we have not yet already mentioned before in this video. Out of the 161 defendants, 17 died before the tribunal could come to a verdict. Another 20 were withdrawn when the prosecution didn't have enough evidence, and 13 were transferred to other courts, believing their crimes weren't severe enough for this tribunal. 10 of them went to Bosnia-Herzegovina, 2 to Croatia, and 1 to Serbia. This leaves just 111 people who were actually put on trial, 21 of whom were acquitted. This was usually because there simply wasn't enough evidence to convict a person, or the evidence wasn't conclusive enough to warrant sending someone to prison for years. This leaves us with a total of 90 people who were convicted for their crimes. Of them, 9 died in prison. 20 are still in prison as of 2023, 58 completed their sentence, and another 3 are currently still in jail awaiting their appeal procedures. The very first indictment was issued on February 13, 1995, against a man called Dragan Nikolic. It took 5 years to arrest him because the Serbian government protected him. In 2000, the Serbian government ousted their leader and began cooperating with the tribunal. He was arrested in the year 2000. He confessed he participated in the killings of his own neighbors and was sentenced to 20 years in prison for crimes against humanity. He was granted early release in 2013 after serving 2/3 of his sentence, and he passed away 5 years later in 2018. The very last court case was against 6 people. They each were important people in the Croatian occupation of parts of Bosnia-Herzegovina, where they were involved in ethnic cleansing. Jadranko Prlic, the political leader of the Croat occupation of Bosnia-Herzegovina. He was aware of the atrocities committed by his troops in this region. He tried to justify deporting thousands of innocent civilians to detention camps, but the tribunal was unconvinced by his arguments. He was found guilty of crimes against humanity, breaking the rules of war, and breaking the Geneva Convention. He was sentenced to 25 years in prison and is currently still there. Bruno Stojic, head of the military police in that region. Because of his position, the tribunal concluded that he should have known that some of his soldiers would commit war crimes, but did nothing to prevent them or stop them while they were happening. He was found guilty of crimes against humanity, breaking the rules of war, and breaking the Geneva Convention. He was sentenced to 20 years in prison and is currently serving out his sentence. Milivoj Petkovic, a Croat general who organized many of the atrocities. He was also found guilty of crimes against humanity, breaking the rules of war, and breaking the Geneva Convention. He was also sentenced to 20 years in prison and is also serving out his sentence. Valentin Koric, a logistics officer who was instrumental in creating a system of atrocities. He was convicted of the same crimes but only given 16 years in prison and was granted early release in 2019. Berislav Pasic, head of criminal investigations of the military police. It was his job to investigate the criminal activities of the military police. However, he took the necessary measures to improve those conditions or to cause the mistreatment to stop. He was still found guilty on some charges and sentenced to 10 years in prison. He was released in 2018 due to ill health. And lastly was Slobodan Praljak, a high-ranking commander in the Croat military. He was aware of the atrocities but did not make serious efforts to stop them. He was found guilty for the same 3 crimes and sentenced to 20 years in prison. A few seconds after receiving his sentence, he drank poison and died on November 29, 2017. The tribunal closed the next month on December 31, 2017. Some of the defendants could still appeal their decision, but this would be handled by the UN's mechanism for criminal tribunals. And so ended the Yugoslavia trials. If you found this video interesting, then please give it a like and subscribe for more content.